out today, so we need you to email it before everything gets closed out. Good morning. You're Linton Arsenault? And Mr. Arsenault, are you currently sick?
Ma'am?
Are you sick right now?
No.
Would you pull that down for me just so, there you go, I can hear you better on the hearing. And Mr. Arsenault, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor. None from the defense.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those. It looks, defense work, it looks worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to penitentiary. He stayed in the state, he stayed in county jail on that. That's my understanding, Judge. And I'm not making light
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I brought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next time, the next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years. I mean, 10 years is a long time for him not reporting for that. So, Judge, I would ask that you consider he doesn't want a trial. He doesn't want probation. He said that he was up front with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right, thank you. Mr.
I
Hoffpower?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version. I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at, and if you aren't, then you're supervising yourself, and that's the problem. So the only reason I think the state and it's up to the court. Obviously, I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't going to come. And he's not going to report. So we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arsenault, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part.
No,
You didn't say that?
no, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register, and you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I went
sense.
in front of Judge Stevenson. What?
No, You went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender.
Yes, ma'am.
So you did know you have to register, because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Good morning. Are you Ryan Hodge? And Mr. Hodge is charged in cause number 24, DCCR 1167, with evading arrest or detention with the use of a vehicle. And Mr. Kimmler, what is the announcement?
Your Honor, the state has suggested that perhaps I sit down with Mr. Hodge. He's from out of state. He lives in Oklahoma, and look at the video from this, so he can be perhaps better aware of the circumstances of the case.
I would think that would be important.
He's not prepared to enter a plea.
So here's what I'm going to do. I'm going to reset the case just one time. Mr. Hodge, while you're in town, get with Mr. Kimmler. Y'all figure it out. I want you to take a look at that video between now and the next court date so we can get an announcement at the next court date. Okay.
He had, I'm sorry to interrupt, he had been on quite a few jail dockets, and now that he's out on bond, he has Mr. Kimmler. I did suggest that them watching the video together before the next announcement would be very beneficial. I do have a concern with his out-of-state residency, not necessarily that he remained here, but he has some felony priors in Oklahoma, Judge, and I don't know if the court might think it advisable to have him put on the GPS so that we know where.
I'm sorry.
You're already on a GPS?
Yes, ma'am.
Okay.
For my bonding.
Okay. Make sure you follow all of the conditions of your bond, whether it's court conditions or conditions with your bonding company, okay? And again, make sure you get with Mr. Kimmler. I want y'all to watch that video before that next court date.
Yes, sir.
Okay? All right, you're free to go.
Thank you, ma'am.
Good morning, sir. You are Ronnie Oliphant. And in 25 DCCR 0379, Mr. Oliphant is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We were just asking for another reset date so we can have more time to investigate.
Any issues, miss, that you see notated? All right, looks like you guys were hired at the end of July. I'll reset it another time to give you some time to try to get all that discovery and evidence taken care of. Mr. Oliphant, make sure you stay in touch with your attorney so you guys can go over everything, what your options are, and we'll see if we can get an announcement at that next court date.
Thank you, Judge.
All right, you're free to go. Thank you. Good morning. Are you James Allen Bruno? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Bruno, in cause number 24, DCCR 1151, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from April 21st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 6-year deferred adjudicated probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bruno is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Ms. Malfino?
Judge, he's not from here. I have a little bit of hesitation with his Louisiana history. If he does, in fact, have any, I cannot see any in NCIC, TCIC, but due to the fact that he's not local, of course, defer to the court, but I would appreciate if we could just hold him for those couple of weeks with PSI coming.
Your Honor, the only record I know he has a misdemeanor marijuana charge from way back, and there's no felony history at all.
So where are you going to live when you're released? Where do you live?
I live in Louisiana.
Where in
Lafayette.
Louisiana? Lafayette. So,
In Baton Rouge.
I'm sorry.
He works in Baton Rouge.
Okay, so here's what I'm going to do, Mr. Bruno, based on the nature of your plea. I'm going to reduce your bond in your case to $1,000. Until sentencing, if you make that bond, I am going to require that you wear a GPS monitoring device. And so you'll need to get that taken care of. They'll put it on at the jail. That's just to make sure we know where you are and to make sure you get back here for your sentencing, okay? Once you get on probation, I don't anticipate that you'll have to continue wearing it. That's just a bond condition to make sure, since I lowered that bond, that you have that incentive to come back when you're supposed to, okay? All right. Okay, thank you, sir. You can go back with the bailiff.
Well, Your Honor, also he might tell him if he gets out about...
Oh, yeah, so
Sorry.
Mr. Bruno, yeah, thank you. So also, if you make that bond before probation comes to talk to you at the jail, don't go straight to Louisiana, go straight to probation. Okay, you've got to go straight there. She's going to give you some paperwork today that shows you where to go. You've got to do that interview and get that appointment made for that pre-sentence report. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be worse.
No, I understand.
And then also, if you're arrested for anything, obviously between the time you bond out and if you come back for sentencing, you've been arrested, then you run the risk of me not accepting that agreement. Okay? Thank you, sir. You go back with bailiff. Thank you. Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it, and all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous, okay? All right, go back with the bailiff. I'll reset the case. Good morning, you're Guillermo Galvin, and this is 24 DCCR 2321. Mr. Galvin is charged with driving while intoxicated, third or more, and what is the announcement?
Judge, this is going to be refiled as a misdemeanor, and we have a couple of weeks to get that refile done in the police set in the misdemeanor court, and once that's done, I'll send the paperwork to Ms. Morfino, and she'll submit a dismissal.
All right, so what I'll do a normal reset. That gives y'all hopefully plenty of time to get that taken care of. If everything works out, you don't have to come back to this court. If for some reason it doesn't happen before the next court date, then we'll just need to come back here and get an update.
Judge, he's provided over the pendency of this case quite a bit of documentation with respect to his attending rehab, having a handheld that he uses 3 times a day, I believe, kind of around his work schedule. I think Johnny's or whomever in error sent another of Mr. Crenshaw's clients with the last name similar to me to confirm all of the negatives on that. So if I could just get that documentation corrected, we'll take care of it and have a date certain.
Okay.
And I
Sounds
did
good.
send the correct documentation to her this morning.
Okay, perfect. Sounds good. All right. Well, we may see you back in 30 days, but hopefully not.
But Judge,
Okay.
just to be on the safe side, can we still admonish him that with respect to having that handheld, continuing it until depleted?
Yeah, you're still under all the same bond conditions, so make sure you continue to do everything you're supposed to, and then once you take care of that case, you'll have certain conditions of any probation. You'll be required to follow those too.
And at that point, we'll determine whether an interlock or continuing with that
Sure.
handheld would be best.
Okay. Sounds good. Thank you.
Thank you, Judge.
Mr. Kimler, we lost Mr. Kimler and Ms. Holmes. Oh, she's done, huh? Oh, no, we've got a drug test on hers. And then we've got Mr. Gertz and Mr. Kimler. Good morning, you're Seneca McDaniels. And what is the announcement?
Judge, with the court's permission, based on the underlying facts of this case themselves, we have agreed to forfeiture of this weapon. He has brought payment already today. We just need to figure out who to make it out to, and he's going to plead down the hall hopefully in 2 weeks. We can get it in the county court through for his homes.
So what I'll do is just a normal reset here. That should all hopefully be taken care of. If for some reason that's not taken care of before the court date here, make sure you show up when Ms. Holmes tells you to, okay? Okay, you're free to go. All right, and court. Good morning, are you Charles Newman?
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
Your Honor.
Mr. Newman, in cause number 25, DCCR 0545, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from November 22nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And it looks like there's a co-defendant's case that would get dismissed based on this plea, correct?
Yes, that's correct.
Also, do you understand, sir, that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Newman's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see you back at sentencing.
Discovery?
Yes. Mr. Gilmore, you have your discovery. Good morning, you're Patricia Benton?
Yes, ma'am.
And Ms. Benton, did you get someone hired?
I have not, no, ma'am.
Okay, who'd you?
I've contacted Corey, Brittany Holmes, Mr. Macon, and Corey Crenshaw, but I just can't afford them.
And you're working?
Yes, ma'am.
Okay. And are you working full-time?
Yes, ma'am.
Okay. So what I'll do this morning, I'm not sure if you'll qualify, but I'll have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. And then I'll take a look at it. Step in front of the clerk, she'll give you that paperwork. Just a minute. Good morning. You're Christopher Pickens. Good morning, Ms. DeLage.
Good morning. Sorry, Judge.
That's okay. I've got Mr. Pickens here and Mr. Smith in cause numbers 24 DCCR 2275 and 2276. Mr. Pickens' cases are set for trial to begin with jury selection on Monday, September 29th, yeah. And so I know, Ms. DeLage, you had mentioned to my clerk that you were going to file a motion for continuance, but we don't see that. Did you get that filed?
I did. I first received some kind of weird error that said the e-filing system couldn't process it, something I'd never seen before. So then I refiled it in the same envelope. That caused another error. And so then I refiled it again in a new envelope, and I don't have any results from that.
Okay, and what is the, I guess, just let us know, since you're here, what is the purpose or the reason for that motion?
I am on my way to a trial skills training in Austin and knew that I wouldn't be dressed and available.
No, but for trial's not until the 29th, so can you be ready?
Oh. Yes, I can be ready for the trial on the 29th. I just couldn't be there today.
Gotcha. All right, and has there been any other negotiations or anything like that?
Okay.
And so, Mr. Pickens, you still want to go forward with your trial, is that correct? All right, so what I'll do is number the cases tomorrow after the docket, and your attorney will get that trial order, and she'll let you know when you need to be back on the 29th. Yes, sir. Stay in touch with Ms. DeLage, and that way, if you're at the top of the list, you guys can get together and start, make sure you're prepared, okay?
Yes,
Thank you for zooming in, Ms. DeLage. And
No problem. Thank you, Judge.
Thank you. All right, you're free to go, sir. Yeah.
Vegas last night.
Oh, nice. It's hard to feel sorry for you. Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing. Negative. All right, sir, Ryan Eric January. Speak up, please. And Mr. January in cause number 25 DCCR 0370 was previously in court, entered a plea of guilty to the third-degree the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have.
Any additions or corrections? So I guess I had a question. I did not realize if we do this on all or if but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or,
We have,
I'm sorry.
I can look into it for you, Joe.
Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me.
Yes,
Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life. And so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you can talk to probation. They'll let you know how to get started on that. And you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a probation conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir. Good morning. You are Catherine Castillo, and Ms. Castillo has 2 cases. She's assault of a peace officer and then also driving while intoxicated, 3rd or more. And what is the announcement?
Your Honor, we need 30 days. I've received all the discovery. We're going to review the video evidence. I have an offer now. I'm going to relay that to her. We'll meet before we come back, and the case will be disposed of on that day.
Okay, this will be the last for an announcement. Ms.
Absolutely.
Castillo, make sure you get with Mr. Pageant. Now that he has everything, you guys can go over all that discovery, see what your options are, and we'll take care of your case at the next court date.
Yes, ma'am.
Okay, you're free to go. Thank you.
Thank you, Your
Mr.
Honor.
Pageant.
May I be excused?
Yes. I don't know how that got over there. What did I do?
Her screen. Just grab it and pull it
I
like
see
you
it
do
now.
your Zoom, Judge.
Oh,
Pull it to you.
but I'm not even clicking it, and it's just moving.
Sometimes it just does click.
Put it there.
Now grab it.
I can't see it over here still.
There you go.
Don't call me mom.
Wait.
We're not.
Okay. All right, you're Daniel Spencer Ybarra?
Yes, ma'am.
And Mr. Kimler, will your client waive the formal reading of the indictment in each case?
She will, Your Honor.
And it looks like we're going on the entire, all of the,
This is second degree.
okay, so Mr. Ybarra, in cause number 24, DCCR 1722, you're charged with the state jail felony offensive theft with previous convictions. That's from April 28th of 2024. And the indictment alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, 2 cases on February 7th of 2007, September 27th of 2010, May 4th of 2011, and then the indictment,
Oh, I'm sorry.
I know, but he's trying to pay attention to me. The indictment further alleges that you were previously convicted of burglary of a vehicle, a 3rd-degree felony, May 19th of 1986, in 2 cases. And then after those were final, you were convicted of delivery of marijuana, a 3rd-degree felony, November 30th of 1987. Also, delivery of marijuana that same date, November 30th of 1987. And after all of those were final, you were convicted of prohibited substance in a correctional facility, a 3rd-degree felony, July 31st of 1999. And after that was final, you were convicted of driving while intoxicated, a 3rd-degree felony, January 5th of 2000. And after that was final, you were convicted of driving while intoxicated, 3rd-degree felony, October 29th of 2009. And how do you plead to that charge?
And I'll get the volume.
So you're guilty of the offense you're charged with, and are all those priors true?
Yes, ma'am.
And then in cause number 24, DCCR 2289, you're also charged with the state jail felony offense of theft with previous convictions. This is from September 28th of 2024. It alleges all of those same prior offenses, and how do you plead in that charge?
Guilty of everything, no?
Did you enter your pleas of guilty and true in each of these cases freely and voluntarily?
No, I did.
And because you're guilty, you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
And do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow any agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am, I do.
And it looks like the agreement that you've reached is for a cap of 10 years. The way the allegations and the prior convictions make these for punishment purposes a second-degree felony. The agreement is to cap your punishment at 10 years. Leave it up to me. You have an absolute right to have a jury come in and determine two things. One, if you're guilty or not, and then secondly, to leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am, it is.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. And also, sir, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I do.
And is there any evidence that Mr. Ibarra is not competent?
None to my knowledge, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases so that the probation department can do a pre-sentence report, and then we will come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Kimler and the pre-sentence officer, and then when you come back, they will present it to me on your behalf. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there.
Thanks, Your Honor.
All right, we'll see y'all back at sentencing.